good friends, Senator Paul, who said, well, that's all good, but sometime in democracies you elect very bad, bad people. And I don't want to give the power to executive branch this broad that could result in political persecution. I will tell you, Senator Levin, you may find this hard to believe, but there are people on my side who really don't trust President Obama, his administration. Some of them don't think he's an American. Some of them believe that if we pass this law, that you're going to give the Obama administration the power to come on and pick them up because they go to a rally somewhere. All I can say to Senator Paul and others, I share the concern about unlimited executive power. I support the Posse Comitatus Act. I don't support the idea the military can't fight Al-Qaeda when they come here. We're not talking about law enforcement functions. But here's what happens. If someone is picked up as a suspected enemy combatant under this narrow window, not only does the executive branch get to determine how best to do that, do you agree with me that in this war, that every person picked up as an enemy combatant, citizen or not, here in the United States, goes before a federal judge, and the government has to prove to an independent judiciary outside the executive branch by a preponderance of evidence that you are who we say you are and that you fit in this narrow window, that if you're worried about some abuse of this, we've got a check and balance where the judiciary, under the law that we've created, has an independent review obligation to determine whether or not the executive branch has abused their power, and that decision can be appealed all the way to the Supreme Court.
That guarantee is called habeas corpus. Been in our law. It's untouched by anything in this bill. Quite the opposite. We actually enhance the procedures here, and the Senator from South Carolina has been very much a part of the effort here.
Much to my detriment.
You know, with all the risks that are entailed of being misunderstood and all the rest. That is something that the Senator from South Carolina has engaged in to try to see if we can put down what the detention rules are, by the way, because as the administration itself said in its statement of administration policy, that the authorities codified in this section, authorities codified in section 1031, they're referring to, those authorities already exist.
And Senator Levin, so in this case of where somebody's worried about being picked up by a rogue executive branch because they went to the wrong political rally, they don't have to worry very long because our federal courts have the right and the obligation to make sure the government proves their case that you're a member of Al-Qaeda and didn't go to a political rally. That's never happened in any other war. That's a check and balance here in this war, and let me tell you why it's necessary. This is a war without end. There'll never be a surrender ceremony signing on the USS Missouri. So what we've done, knowing that an enemy combatant determination could be a de facto life sentence, is we required the courts to look over the military's shoulder to create checks and balances, and quite frankly, I think that is a good accommodation.
Now, the reason this is framed this way is that there is a historical exception under constitutional findings of the Supreme Court to Amendment 5 and Amendment 6 of the Constitution. And that exception is that if an individual is fighting on the side of the enemy against the United States, that they do not have the same rights because they are now an enemy combatant in time of war, and they can be detained for the duration of that conflict. And this was adjudicated in World War II over individuals who assisted with sabotage in New York. And it was found that the standard rights, a speedy public trial, trial to jury, right to counsel, do not apply if you're an enemy combatant. Instead, you're put into the framework of a war setting to be treated as a member of the opposing army. So this exception has historically been extremely narrow. You are on the battlefield, or you are directly working as a member of the enemy force against the United States. It should be extremely narrow. And it should be substantial hurdles for the state to be able to simply claim that you're an enemy combatant and thereby strip you of your Fifth and Sixth Amendment rights. But what we have in this bill in Section 1031 is not this narrow set of provisions based on the historical understanding of an enemy combatant. Instead, we have a definition that says, and I will read it to you, a person who was a part or substantially supported Al-Qaeda, the Taliban, or associated forces engaged in hostilities against the U.S. or coalition partners, including any person who has committed a belligerent act or has directly supported such hostilities in aid of enemy forces. On first reading, it may sound like that individual who is directly involved in combat, but listen to the words embedded in this. First of all, it says a part of, with no conception of what a part of means. Did you write one sympathetic email in your lifetime? Does that make you a part of? We have no standard here. Substantially supported is understood to mean material support, but no contingency for intent. If you donated money to a charity and that charity used it to support Taliban activities somewhere in the world or some other group that had an association with Taliban, you have substantially supported under this conversation. Then it says the U.S. or its coalition partners. Who are these coalition partners? What's the definition of that? Now, a few weeks ago, you might have noticed in the news that there was a lot of protests going on in Bahrain. Well, we have a military facility in Bahrain. Is Bahrain a coalition partner since we utilize a partnership with them to supply our forces in the Middle East? Yes, probably so, because there's no definition of coalition partners. Well, with individuals who were standing up for human rights and got into a battle with police in a public square, they are engaged in a belligerent act against a coalition partner. So I hope you can start to see that the standard understanding that has been constitutionally established over time is completely taken apart in this simple paragraph. That should be of grave concern to all Americans who care about our constitutional rights to a fair hearing. I would like to conclude by summarizing that all that we hold dear as Americans in this Constitution about our fair rights as citizens has been trampled on tonight. That this has happened twice before in this chamber, and the Supreme Court has thrown it out twice before. I hope that they will find a case that this will put before the court again, because it is the responsibility of the court to keep taking us back to this document, this Constitution, when we waver from the course it lays out. It should not be a situation that the government can simply assert that the president, no matter what president it is, this president or any future president, whether it be President Bush, whether it be President Obama, whether it be the next president of the United States or 5 presidencies into the future, should not be able to say, you, Joe American, I'm calling you an enemy combatant. I am locking you up. I'm assigning your defender, your court attorney, if you will. I'm deciding the rules of evidence. I'm deciding if it's going to be secret. And after I conclude that there's enough evidence because of a partial fingerprint, I'm locking you up forever, and there's not a damn thing you can do about it. Now, Brandon Mayfield was locked up. And he might have been locked up forever. if this law had been in place. But the FBI made a mistake. FBI completely botched the fingerprint comparison. It was Spain that brought it to our attention. Spain kept saying, America, you've got the wrong guy. America, you have the wrong fingerprint. And it was Spain that found the right match. And it was finally our own system said, yes, we made a mistake, and we're setting Brandon Makefield free. But under what was done tonight, he may never have seen the light of day outside of his prison. And that is not right, and it is not, absolutely not, a contributor to the security of this country to strip away fair rights of due process, to summon the evidence, to confront your accusers, and make sure that a just decision occurs. Thank you, Mr. President.